Good afternoon, and thanks for joining us for today's crash course in employer immigration compliance, a labor, employment, and human rights webinar. While I introduce myself and today's speakers, please see the information slide that is on your screen. My name is Delphine Culat. I'm an articling student at Fasken's Quebec City office, and it is my pleasure to introduce our cross-Canada panel for today's session. Elisabeth Bouffard is a senior lawyer based in Fasken's Quebec City office. In addition to advising businesses on a variety of employment law issues, she also counsels her clients in global mobility strategies, particularly for intercompany transferees and business visitors. She assisted several employers experiencing compliance issues related to immigration programs by conducting internal audits or by supporting them during an inspection process. Next, Stephanie Heinsohn is an immigration lawyer based in Fasken's Montreal office. She advises clients on a broad range of complex immigration matters and has worked with multinational corporations, small businesses, and individuals alike to assist them with their temporary and permanent immigration matters. Her practice is also focused on employer immigration compliance. And last but not least, Daniel Lee is an immigration lawyer based in Fasken's Vancouver office. He advises and represents clients in numerous areas related to immigration with a focus on corporate immigration law, employer immigration compliance, and global mobility. And now on to our presentation. So today's session will cover 4 topics related to employer immigration compliance. First and foremost, a quick introduction on the different types of immigration programs and compliance regimes in Canada. Second, an overview of employer obligations under both regimes, followed by an explanation of what a voluntary disclosure of noncompliance consists in and what are its impacts, to finally provide you with a step-by-step of what a compliance inspection looks like. There are 2 programs under which employers can hire temporary foreign workers in Canada. So first, we have the Temporary Foreign Worker Program and the International Mobility Program, or the IMP. So both programs come with a different set of obligations for the employer. But before we get into that, allow me to briefly explain those 2 programs and what sets them apart. So under the Temporary Foreign Worker Program, the hire of a temporary foreign worker needs to have a positive or neutral impact on the Canadian labor market. What this means essentially is that the worker that the employer hires must be hired in order to fill an existing gap in the Canadian labor market. So under the Temporary Foreign Worker Program, employers can only hire under closed work permits, which means that the worker is hired to work specifically for that employer. So contrary to an open work permit, a closed work permit is not a blank check to work anywhere in Canada for a determined amount of time. You need to work for that specific employer. And so in order to submit a work permit application under the Temporary Foreign Worker Program, there are 1 or 2 prerequisites depending on the province. So regardless of what province or territory you are as an employer in Canada, before you can submit a work permit application, you need to obtain a positive labor market impact assessment from Service Canada. And what an LMIA essentially analyzes is whether the hire of a temporary foreign worker will have a positive or neutral impact on the Canadian labor market. But if you're an employer in the province of Quebec, in addition to the LMIA, you also need to obtain a Quebec acceptance certificate, which is essentially like a mini LMIA, but for the province of Quebec. Under the Temporary Foreign Worker Program, you can hire 6 types of temporary foreign workers under 6 different streams. So you have the low-wage stream, the high-wage stream, the primary agriculture stream, the global talent stream, the caregiver program, and then finally the permanent resident program, which is sort of a fast track to permanent residence in Canada. So the purpose of this presentation is not to present those streams in greater detail, but should you have any questions, please ask one of us and it will be our pleasure to provide you with additional information. Regardless of the stream through which an employer hires a temporary foreign worker, like I've said, the employer needs to obtain an LMIA beforehand. When the LMIA is signed online, which is the usual process, at the end of the application process, there's a list of commitments for the employer on the screen, and the employer has to confirm that it has read them before the LMIA can be submitted. So it's a box that the employer needs to check on its screen. So think of it sort of like the terms and conditions when you buy something online, except that for the employer obligations, you really need to read them. You can't just check the box like with your terms and conditions when you buy something online, because it's very important for your compliance as an employer to know what your obligations are. Next, under the International Mobility Program, or the IMP, the hire of a temporary foreign worker aims at providing economic, cultural, and other advantages from Canada. So you can understand from that description that it's a lot broader than the temporary foreign worker program, which I've just explained. So under the IMP, the hire of a temporary foreign worker does not require an LMIA, regardless of whether you hire a worker under an open work permit or a closed work permit. Because contrary to the temporary foreign worker program, you can hire a temporary foreign worker under both types of permits. So starting off with open work permits, they're typically reserved for temporary foreign workers under the International Experience Canada program, or the post-graduation work permit program, or for spouses of temporary foreign workers. If you're an employer and you're looking to hire a temporary foreign worker who already has an open work permit, make sure to ask for the original work permit during the hiring process in order to review its conditions. So you'll want to make sure whether it's really an open work permit, if it specifies the place of employment, what is its validity period, or if it has any other specific conditions. And that is the first step in making sure that you as an employer are compliant with your obligations. So closed work permits, on the other hand, involve a bit of a different process under the IMP. So before you can submit an application for a closed work permit, there needs to be an employment agreement, a signed employment agreement between the employer and the temporary foreign worker. So once that employment agreement has been signed, it needs to be submitted online through Service Canada's employer portal, and the employer needs to pay a $230 compliance fee in order for the permit application to be submitted. Under the IMP, closed work permits are usually for temporary foreign workers coming to Canada under international agreements or reciprocal employment agreements, or for temporary foreign workers who fulfill Canadian interests, such as workers with unique work situations, entrepreneurs, startups, or francophone mobility. Like under the temporary foreign worker program, when you submit an application for a closed work permit online, the employer has this list of commitments on its screen, and it needs to confirm that it has read them. So because I've now talked twice about that list of commitments, here's a print screen of what those commitments look like when they're on your screen. That list of employer commitments that you can now see is essentially a list of all the employer obligations that are provided for by the Immigration and Refugee Protection Regulations, which Stephanie and Daniel will be outlining next. So without further ado, I will move to it.
Thanks, Delphine. So I'll talk about some of the employer compliance obligations, and some of these obligations apply to both the temporary foreign worker program and the international mobility program. Next. So whenever there is an immigration inspection, we need to ensure that all the employer obligations are complied with. And if they're not complied with, there are situations where we can provide justifications. Examples of justifications include, for example, there are changes to the law, or it was administration error, or the error did not result in any detriments to the temporary foreign worker. So when there is a finding of non-compliance, what usually happens is for really minor cases, there could just be a warning letter. The warning letter itself does not affect any future work permit application. If the noncompliance becomes a little bit more serious, the penalty can include either a temporary ban from using the temporary foreign worker program or international mobility program, and this could be as serious as a permanent ban. There's also administrative monetary penalty, and usually it is up to $100,000 per violation, and the maximum amount per year can be as high as up to $1 million. The worst part of finding a noncompliance is the noncompliance will be listed on the Immigration Canada website, and this could cause reputation damages to companies. Next. What's also important for employer is if there is a finding of noncompliance in any existing work permit applications under the temporary foreign worker program could be paused, and existing labor market impact assessment work permit could also be revoked as well. So because it has an impact on both existing work permit and future work permit application, it is very important to ensure we understand what those employee compliance obligations are. Move on to the next slide. I just wanted to show you that there is a website and the link is provided. You can click on this website, and this website would indicate to you the companies that are currently not in compliance with immigration law. So the business name would be on the website, including their address and the reasons for non-compliance. The number under the reasoning section refer to the specific section that the employer has not complied with the immigration regulation. And it also have like the penalty and indicate to you whether or not the employer is currently eligible to hire foreign workers under the temporary foreign worker program or international mobility program. So now I'll turn to Stephanie to talk about the obligations for both programs.
Thanks, Daniel. So now that we have seen the risks that are associated with non-compliance, we're going to dive a little deeper into what each of those obligations are. I'm going to start with outlining the obligations that apply to both regimes, so both the temporary foreign worker program and the international mobility program. And then Daniel will end with some obligations that are really specific to the temporary foreign worker program, so specific to work permits that require an LMIA. So beginning with the first one that applies to both regimes is document retention, and for a period of minimum 6 years. The employment period of 6 years, starting from the first day of the foreign worker's employment period. This is because immigration authorities can inspect the compliance of the employer with respect to the employment period of a foreign worker up to 6 years after the first day of their work. So this is why it's important, and we always recommend that whenever an employer is hiring a foreign worker, to retain all documents pertaining to their recruitment and employment for a period of up to 6 years. And what we mean by documents, if you can move to the next slide, please. So documents, think of any documents that you would normally include in a regular HR employee file. So employment agreements, special letters agreement that you have agreed with the specific employee, but it goes even further. You also need to include specifically for foreign workers, work permit copy, the LMIA decision, the CEQ decision letter if you're employing someone in Quebec. Also important to keep any receipts as proof of payment that you paid for any processing fees wherever it's required. As we'll see a little bit further, there's specific processing fees for many of these immigration processes that are mandatory. It is mandatory for employers to pay for and are not, and it is not permitted to recover from the foreign worker. Also important, any employment records, T4s, Relevé 1 for Quebec, anything that is relevant to demonstrate compliance in case of an inspection. Just make sure to keep a file and to retain it for a period of 6 years at a minimum. Next slide, please. Another one that we will cover is proof of active engagement in the business. So whenever an employer hires a foreign worker, it's important that that the employer knows that they need to demonstrate that throughout the entire employment period of the foreign worker, they are actively engaged in the business that they declared in the application. So they need to have active operations during the entire time. And this is important to remember because this is something that immigration authorities can inspect as well. They can request documents such as commercial leases, business licenses, permits, incorporation articles, CRA business numbers, and they can even go as far as to just verify publicly available information. So they could look at company websites and news articles as well. Next slide, please. So maintenance of employment conditions is the next obligation. This one comes up quite often. So if you hire foreign workers already, this one may be more familiar to you. Essentially what it is that employers need to be aware that when they hire a foreign worker, changes in the employment conditions are much less flexible as compared to hiring a Canadian. Not to say that there's no flexibility at all and that changes are impossible. They are, but it's important to be aware of the limitations of these changes. So essentially, when you are hiring a foreign worker, employment conditions must remain the same at all time, with certain exceptions only. What this means is that the employment conditions such as the job title, the job duties, the salary, employment location, any benefits that were declared in the LMI application for the temporary foreign worker regime or in the online job offer for the IMP for LMIA exempt work permits, all those need to remain the same throughout the entire employment period of the foreign worker. And so here on the screen, I have the phrase substantially the same, but not less favorable wages. So it's important when you're about to make a change, either a promotion or just because there's operational changes, maybe business changes, and you need to make changes. Maybe you want to change locations or you want to promote someone. It could be any change at all. Just remember that any substantial change should be a flag for HR to stop and check whether the change that they're about to make to the employee's work conditions, maybe it will require a new LMIA or a new work permit. So before making that change, just check either with your immigration lawyer to make sure that you're not making a change that would be considered to be non-compliant in the case of an inspection. Next slide, please. So as I said just a few seconds before, it's not to say that all changes are prohibited. There are some changes to the employment conditions that can be considered acceptable changes that would not lead to a finding of non-compliance. For example, pay raises to cover inflation. These are generally accepted. So if you need to raise the person's pay, just like you would any other employee on payroll to cover inflation, that's normally okay. Important to be aware of promotions. Some promotions will lead to an occupational code change, so a NOC change, or it would lead to a substantial salary increase. This would normally lead to the requirement of a new LMIA or a new work permit. Some promotions may not lead to an LMIA as long as the duties remain under the same NOC. So it's just little tips and tricks to remind you of what can be considered acceptable versus not. But in case of any doubt, always consult with one of us, and we could definitely guide you to make the best decision before making any changes. Next slide, please. So this one's a pretty simple one, but it's to remember that in addition to immigration regulations and law compliance, employers must also remember to apply general federal and provincial employment laws to the foreign workers as well, because foreign workers have the same rights and obligations as Canadian employees. So it's important to remember what those obligations are and to treat the foreign workers equitably. Inspectors can always check the web to verify negative court decisions and negative press articles to verify whether there's evidence of non-compliance to these general federal and provincial employment laws. So it's always important to keep up to date with these obligations as well. Next slide. So some useful information, some provinces go as far as to require registration and with the provincial government authorities, just to make sure that the employers are being compliant with local labor standards and employment laws. BC and Manitoba, for now, are requesting registration, and then once the employer registers, they will issue a certificate that confirms that they are registered and allowed to hire temporary foreign workers under the temporary foreign worker program. So this means that for BC and Manitoba, you need to register the business before being able to apply for an LMIA. If you're applying for a work permit that's exempt from an LMIA, then this is not a requirement. However, if you anticipate to hire foreign workers in the near future, we would recommend registering as soon as possible, just because there's a lot of applications at the moment. It is a relatively new obligation from the part of Service Canada, so it might take a few weeks before receiving that certificate. So it's important to keep this in mind. Similarly, for Quebec employers, for jobs that are situated in Quebec, employers must remember that they need to register each temporary foreign worker with the CNASST. Next slide, please. The next employer obligation is the employer agreement obligation. So this one, just like you would when you hire a Canadian, it's important to keep in mind that even for foreign workers, they need to have an employment agreement in place that outlines their employment conditions, occupation, wages, salary, anything that you would include in a regular employment agreement for a Canadian applies to foreign workers as well. It's just they're required at different times depending on the regime or the work permit application type that you're going for. So for the IMP, so LMIA exempt work permits, the employment agreement is actually required at the very beginning of the process, even before you log on to your IRCC employer portal to submit the online job offer. In the employer portal, as Delphine showed at the earlier stage of the presentation, there will be a declaration section. So IRCC is essentially asking the employer to declare, amongst other things, that before submitting the online job offer, that there is an employment agreement in place signed by both parties. Next slide, please. So that's the requirement under the IMP for LMIA exempt work permits. Now, for work permits issued under the temporary foreign worker program, it's a little bit different. So the employment agreement is not mandatory at the beginning. So you can submit your LMIA application without the employment agreement in place. The requirement there is that the employer needs to have an employment agreement signed by both parties in place on or prior to the first day of work. So it's a bit different, but in case of an inspection, the timing will matter. So it's important to include a copy of the employment agreement in the employee's file for a period of 6 years. And for the IMP, make sure that the employment agreement is dated prior to the submission of the online job offer, because they can check that. An extra tip for Quebec employers, as a reminder, when you submit an LMIA for a job located in Quebec, you also need to submit a Quebec acceptance certificate application to Immigration Quebec, and they have requirements of their own, and one of them is to have a signed employment agreement by both parties. So outside of Quebec, you can submit your LMIA application without the employment agreement already signed in place, but for Quebec, it's different. You need to have it at the time of submitting your application. Next slide, please. Now, this one comes up often lately. This one is pretty new to most of the employers that we deal with. This was updated last year, and it essentially requires employers to inform the foreign workers of their rights in Canada as a foreign worker. And now the immigration regulations require proof that this was conducted. So immigration authorities will be looking for evidence that this was in fact done in case of an inspection. So right now, what the government is offering is specific pamphlets. These pamphlets are available online. We have them on the page that you see in front of you. You can click directly on the links, and they will bring you to the respective pamphlets that list the employee rights. They're different. They're similar, but the web pages are different for the temporary foreign worker program as opposed to the international mobility program. Next slide, please. So there are a few ways that employers could go about this. There's no clear guidelines for now in the regulations or in the policies from IRCC or Service Canada that dictates how exactly to go about this. So many employers ask us, well, how can I show this in case of an inspection? So there are two ways to do it. One of them is a signed declaration. So perhaps on the first day of work, it could be efficient to have them sign this declaration along with other mandatory paperwork that they'll normally sign on their first day. So a declaration from the foreign worker stating that they have received and read the pamphlet that contains their rights. And if this is not possible, we have seen employers also send the pamphlet in a link in an email. Have the read receipt function on, but go even further than that and have them reply to you confirming that they have received and read their rights. This way, you can retain a copy of either the signed declaration or their written confirmation in an email in their employee file. And if there's an inspection, you will be easily able to demonstrate that you have fulfilled this obligation of providing them with their rights. Next slide, please. Before I go over recovering fees, one last thing to keep in mind for employment rights is that further than only giving the individual foreign worker the information on their rights prior or on their first day of work at the latest, these rights need to be available at all times in both official languages. So again, there's no clear guidelines for now on how exactly to go about this. If you're able to add it on your intranet, and it could be a section where foreign workers can go and check their rights, that's one way to do it. If it's in a manufacturing environment where people work physically at the work site, you can perhaps print the pamphlet and have it at a break room, at a lunchroom, where you know that there's going to be other important information and that it will be easily accessible and easily viewed by the foreign workers. So now on recovering fees, so there are several processing fees, government processing fees involved when applying for a work permit, and a lot of these processing fees are mandatorily need to be paid by the employer and cannot be recovered by the temporary foreign worker. For example, when applying for an LMI application, right now the processing fee is $1,000. And for LMI exempt work permits, there is the fee of $230 for submitting an online job offer, or the compliance fee, as others call it. These fees are considered part of the recruitment process and cannot be recovered at any points in time from the foreign worker. So it's important to keep this in mind. In Quebec, there's the $216 for the labor market evaluation, but on the provincial side, that can't be recovered either. However, there are some fees that are recoverable, and this is good for employers to know. We get this question a lot. Most employers understand that part of the process cannot be recovered, but they ask, what part of the immigration process can I recover? And so the recoverable fees are work permit issuance fees. So once the LMIA, and for Quebec, once the CAQ are approved, or after you've submitted your online job offer for LMIA exempt work permits, well, then you need to submit the work permit application. So the processing fees for the work permit can be recoverable, as can biometric fees, visa fees, or any fees that are related to accompanying family members. So employers are not obligated to pay for those. Next slide, please. So the foreign worker can pay for the recoverable fees on their own. So that way the employer is not involved at all, or the employer could choose to pay everything up front and then ask the temporary foreign worker to reimburse those fees. If you are going to ask the foreign worker to reimburse you, the terms of reimbursement should be clearly discussed at the beginning of the process so that there's no ambiguity between both parties. And if you're going to proceed with the reimbursement via payroll deductions from the foreign worker, then it's important that there is a written authorization from the foreign worker that authorizes the payroll deductions. And so again, just to reiterate that not all fees are recoverable. So it's important to keep in mind which ones are and which ones aren't. And the employer's obligation goes even further now. So some employers will use recruitment agencies or placement agencies to find the foreign worker and will not have the foreign worker on their payroll directly. So this is a question that comes up as well. Like, how far does my obligation go? I won't recover any fees from the foreign worker, but what if the placement agency does, or what if the recruitment agency does? Well, it's important to keep in mind that the immigration regulation does impose a due diligence obligation from the part of the employer. So it's not enough to say that you're not the direct employer, the foreign worker is employed by a third party. Immigration authorities can penalize an employer for not having conducted due diligence to ensure that the third party recruitment agencies are not recovering prohibited fees as well. Next slide. Yes, so the last slide on recovering fees, a lot of times we get questions from employers asking, what about the legal fees? So if you hire an immigration lawyer to help you with all these processes to bring in a foreign worker, they'll charge legal fees for their work involved to assemble and submit these applications on your behalf to the respective government authorities. And there's a controversy surrounding this because some practitioners believe that the legal fees are to be considered separately, that they're not considered part of the recruitment fees and can be recovered, while others consider the legal fees that are inherent to the preparation of the LMIA application, for example, or the CAQ application, as being included in the definition of recruitment fees, and so therefore they advise against recovering the legal fees. So to err on the side of caution, it is best not to recover the legal fees involved in preparing the LMIA, CAQ application, for example. But then it's really a business decision. It depends on the comfort level because there's no definition at the moment on what is included in the definition of recruitment fees, and there's nothing specifying whether legal fees are included in the definition of recruitment fees. But again, any legal fees that occur when preparing the work permit application after the LMIA or CAQ have been already approved, or any legal fees surrounding the preparation of permits for family members, those can be recovered. Next slide, please. Another obligation is access to healthcare. So this one is quite straightforward. It's basically employers need to make sure that there's reasonable access to healthcare for work-related injuries and illnesses. So most employers already have these measures in place because of it being a requirement under other labor standards and employment laws. So if you're following the procedures for that, this should cover that obligation as well. Examples are to just make sure you're up to date on all your health and safety measures. For example, have the required amount of defibrillators, first aid kits, make sure some of your staff is CPR certified, have an on-site phone in case of an emergency. And also another important one is to make sure that your registration with the applicable Work and Health and Safety Commission is always up to date. For example, in Quebec, we have the CNSST. In BC, we have Work Safety BC. So just always remember to keep your registrations up to date, to follow those recommendations of those commissions, and retain proof in case of an inspection, so that immigration authorities can be a great way to demonstrate that you are compliant from a healthcare perspective. Next slide, please. So last but not least is that employers need to remember that they need to offer their foreign workers an abuse-free workplace. And so by abuse, they include in this definition physical abuse, sexual abuse, psychological abuse, financial abuse, and also reprisals. This one is new. This is why we have it in bold. It was updated. The regulation was updated recently to include reprisals. So now employers could be found non-compliant for any disciplinary measures against the foreign worker for having reported instances of non-compliance. So if they even threaten to demote, for example, or fire a foreign worker who has reported a situation of non-compliance, and the foreign worker raises this issue to the respective immigration authorities and there is an inspection, employers can have administrative penalties for this type of behavior. It's always important also as a best practice to implement a policy on psychological and sexual harassment prevention and have a system in place for complaints. This always looks good in case of an inspection because it really puts immigration authorities' minds at ease that there is a system in place and that foreign workers can be offered an abuse-free workplace. Next slide. So that wraps it up for employer obligations that cover both regimes, so both LMIA exempt work permits and LMIA based work permits. And over to you, Daniel, for the temporary foreign worker specific obligations.
Thanks, Stephanie, for that great overview. Next, so for the temporary foreign worker program, they have 6 different streams, and for all 6 streams, employers were obligated to provide private health insurance for emergency medical care until the temporary foreign worker is eligible for provincial or territory health care. One thing to note is for the province of Ontario, there's currently no waiting period. So for a temporary foreign worker, they will be immediately eligible to apply for a provincial healthcare. What's important to note is that when there is an inspection, employer is responsible to provide proof that they have provided the temporary foreign worker with emergency medical care through private health insurance. So the registration document for the temporary foreign worker should be kept for at least 6 years in case there's an inspection. And it is also good practice to request the temporary foreign worker for a copy of their healthcare card. So once the employer receives a copy of the healthcare card, then they can stop providing the temporary foreign worker with private health insurance. Next slide. This is the part where a lot of people ask questions, and this is in relation to providing some temporary foreign workers with affordable and suitable housing. This only applies to 2 specific LMIA stream, and this is referring to the low wage and the agricultural stream. So for employers who wants to hire foreign workers under these 2 specific streams, employer has the obligation to ensure that the temporary foreign worker receive both suitable and affordable housing. Affordable is defined as the cost of the housing does not exceed 30% of the temporary foreign worker's wage before tax. And adequate is usually defined as the accommodation does not require any major repair. For example, like piping issues, ceiling leaking, flooring issues. And it's also interesting to note that Immigration Canada can also come to the accommodation for inspection. So that's one thing to be mindful of. And sometimes for these inspection, the employer may not receive a formal notification. Move on to the next slide. So the requirement to provide transportation also only applies to the low wage stream and agricultural stream. And the requirement is for employers to pay for the temporary foreign worker transportation to Canada and to return back to their home country. The transportation costs cannot be recovered by the employer, even if there is an employment agreement indicating that the transportation costs can be recovered. In these cases, it would not be legal to do so unless the transportation cost doesn't apply to a specific labor market impact assessment stream. In those cases, that's when you're able to recover the transportation costs. So an example of that would be, for example, the high wage or the global talent stream. Sometimes employees would find new employers during the course of their employment in Canada. And if that happens, they change employer. The Canadian employer is not obligated to pay for their return transportation back home. It's important to obtain proof from the temporary foreign worker that they have actually received a job offer from the new employer. So this may be requesting them for a copy of their new employment contract or some sort of like proof that they're working for the new employer. And that could be in the form of requesting for a copy of the new work permit. I'll move on to the next slide. So for each LMA stream, there's some commitments that employers are responsible for. For instance, for the global talent stream, and this is usually for hiring individuals within like IT related occupation, employers are required to enter into a labor market benefit plan. So within that labor market benefit plan, they need to indicate what they be doing to assist Canadians to obtain jobs or hire new Canadians for the company, and also transfer knowledge from the temporary foreign worker to existing employees within Canada. And also there is for the high wage labor market impact assessment, there's a transition plan. The whole objective behind this is to rely less on hiring temporary foreign workers. Within the transition plan, there is the requirement to transfer knowledge or to hire more Canadians. And throughout the employment of the temporary foreign workers, the employer would receive potential requests to provide proof that these labor market benefit plans or transition plans conditions has been fulfilled. And if they are not fulfilled, it may result in the employer not able to use the temporary foreign worker program to hire new temporary foreign workers. I'll move on to the next slide. So during the COVID time, there are specific obligations that were introduced, and when we look back at it right now, it seems like the COVID was a really long time ago. There are a couple of things that we need to be mindful of, despite the fact that COVID is over right now. These COVID-related inspections would last for a total period of 6 years. So COVID ended in 2022 last year. So these inspections relating to COVID compliance would be in place until at least 2028. So a few things to be mindful for. One of them is employers are not allowed to prevent their temporary foreign workers from complying with the Emergency Acts, the Quarantine Act, or any provincial health law. Also, if the temporary foreign worker is required to quarantine, then the employer is required to pay them for that period of time. And unlike the regular inspection, inspection related to COVID, the response period is actually much less. We only have 1 week to provide the response, whereas for a regular inspection, we have up to 30 days to do so. I'll move on to the next slide. So one really important thing with regards to the COVID consideration is like this is not specifically for COVID. So in the future, if there's any related pandemic, the same requirement could be reintroduced. So it's important to make sure we have all these information documented, because one of the requirement includes providing like cleaning products. So one way to ensure that we have provided cleaning products is to maintain those specific receipts. What I'm going to do right now is I switch over to Elisabeth, and she'll talk about voluntary disclosure. Thank you.
Thanks, Stephanie and Danielle. You gave some very useful tips for employers to comply with their obligations and also to get prepared for an inspection. So in the second part of this presentation, what I'd like to do is to give an overview of the compliance inspection process and share my experience with this process. I assisted quite a few employers with major non-compliance issues and complex inspections. So I have prepared some homemade case studies. Please note that those case studies are entirely fictional, because I have my duty of confidentiality. So I just tricked a little bit some cases I've had into homemade case studies. The inspection process may be very stressful for clients. The deadlines given by the inspector can be very tight. Therefore, my main intention as legal counsel is to respond very clearly to the inspector's requests and find solutions to avoid monetary penalties as much as possible. We need also to preserve the employer's reputation and ensure that the employer remains eligible to hire temporary foreign workers. If an employer requests our assistance with a compliance issue, or if we find a potential non-compliance in the context of an internal audit, we will review the possibility to submit a voluntary disclosure to the immigration authorities. So next slide. Yeah. So the purpose of a voluntary disclosure, basically, when employers think that they might be non-compliant with one of the regimes, so the temporary foreign worker program or the international mobility program, the employer can submit a voluntary disclosure to Service Canada or Immigration Canada, depending on the regime. This is very important to note that a voluntary disclosure cannot be submitted if a compliance inspection has begun. It's always prior to a compliance inspection. If an employer submits a voluntary disclosure after the reception of the initial letter announcing the beginning of a compliance inspection, the disclosure will not be taken into consideration by the inspector in his final assessment. Voluntary disclosure can only be accepted for violations that are not severe. For example, overtime mistakes might be considered as not severe. However, physical violence, physical abuse is likely to be considered a serious violation. voluntary disclosure must be made in a timely manner, which means that an employer, if an employer discovers errors on payrolls, it cannot wait months to inform the immigration authorities. The employer must prove that the corrective actions were made right away and submit the situation immediately to the authorities. The voluntary disclosure must also be complete. Complete means that the employer did not hide any relevant facts on the situation. For example, an employer who wants to hide some important facts to make the situation looking like a minor compliance issue instead of a major compliance issue. If the voluntary disclosure is not complete, this will not be taken into consideration by the inspector. For employers who are found non-compliant, the principal purpose of a voluntary disclosure is to get the chance to receive a reduction of their monetary penalties or avoid a ban from the temporary foreign worker program or the international mobility program. What employer, yes, next slide, please. Yeah. What employers need to know is that a voluntary disclosure might trigger an inspection. Therefore, we will always try to manage the risks before submitting such disclosure. From my experience, I will always look at the employer's history of voluntary disclosures. So my recommendation might be different if it's the first or second voluntary disclosure. And if it's the 10th voluntary disclosure, my recommendation might change, actually. I will also review the type of violation, its severity, the number of temporary foreign workers already hired in the workplace can also be a factor that I might want to take into consideration, since a decision of non-compliance might affect the renewal of work permits. Also, prior to submit a voluntary disclosure, I will always organize the appropriate corrective actions with the client to fix the compliance issue and prepare a plan with them to prevent recurrence. We must show to the authorities that every required measures were taken. If I take my previous example on the overtime mistakes, an appropriate corrective action would be to make sure that every concerned employee receives their missing overtime wage on their next pay, and the plan to prevent recurrence must be to identify why the overtime mistakes occurred. For example, if it's a mistake in the pay system, and how this problem will be corrected by the employer. Next slide. I will also evaluate the possible consequences of a determination of non-compliance. So the regulations provide a detailed and potentially confusing, because it's a federal regulations and it's always like quite confusing, point-based system. So the point-based system will classify each violation into 3 types. The point-based system will also make distinction between if the employer is an individual, a small business, a large business, and also the points and points may be added to reflect the compliance history and severity of the violation. We talked about the voluntary disclosures. So the total number of points may be reduced by 4 if the employer makes an acceptable voluntary disclosure. Where an employer has committed more than one violation, the number of points in respect of each violation is calculated separately. As such, an acceptable voluntary disclosure and the associated points reduction is likely to be applied to each violation separately. So basically the goal is to, when we submit a voluntary disclosure, is to get 0 point at the end, but it's not always possible, but it's the main goal. We must also note that a violation that affects more than one temporary foreign workers constitute a separate violation for each temporary foreign worker. Therefore, if many workers are affected, the number of points is likely to increase, and the employer might face severe monetary penalties and a ban from the programs. Next slide. So we will talk about the conduct of a compliance inspection. So first, what triggers an inspection? So most inspections are from a random selection. So it's most of the time employers from the temporary foreign workers who are more likely to be randomly selected for an inspection. Other inspections are triggered by a suspected non-compliance, such as a complaint from a temporary foreign worker. Sometimes during the inspection process, we soon realize that a temporary foreign worker applied for an open work permit for vulnerable workers. And this is why it triggered an inspection. I cannot confirm that an application for an open work permit for vulnerable workers automatically triggers an inspection, but I am under the impression that it might be an explanation in some cases for the inspection. For example, a temporary worker might want to work for another employer, but his closed work permit prohibits him to do so. Therefore, he applies for an open work permit for vulnerable workers, and when his work permit is approved, he quit his job. 2 weeks after his resignation, the employer receives an initial letter for an inspection. And during the inspection, the employer discovers that the ex-employee alleged that his supervisor threatened his life, which is completely not true. The inspector interviews the employees, the manager, and finally found that there was no violation on the part of the employer. This situation might be quite frustrating for employer because the ex-employee used a program available for vulnerable workers to get an open work permit. And the new work permit cannot be canceled even following the inspector's finding. Moreover, the inspection process could delay the processing of a LMAA application submitted for the renewal of other temporary foreign workers' work permits. And so this is sometimes really frustrating for employer to be faced with this kind of situation, but it happened quite sometimes. Next, we have history of non-compliance. So usually employers who were found non-compliant might be inspected more frequently. I cannot say if they are inspected every 6 months or every year, but they will be inspected more frequently than other employers. For COVID-19 related concerns, from my experience in 2020 and 2021, COVID-19 concerns were addressed along with other suspicion of non-compliance for other obligations. So we needed to manage the non-compliance for the other obligation and also potential non-compliance for COVID-19 related concerns. In 2023, inspectors might still ask for documentation related to the COVID-19 obligation for temporary workers who landed during the pandemic. Usually they want to ensure that the temporary foreign worker received their wages during their quarantine or during their isolation. So next slide. Who conducts the inspections? This is interesting to know that many officers might be involved in the inspection process depending on the complexity of the case. So when an employer might be found non-compliant, we want to know which person in the process is the decision maker, because we want to know to who we need to address our concern for potential penalties. The position we listed here, we think that it is the titles used by Immigration Canada or Service Canada, but it might be other titles. I will just explain the process and the task for every position, but I'm not sure about the titles. So it is from my point of view as legal counsel for employers. So the first level reviews are usually made by junior analysts. Junior analysts can make final compliant decision on straightforward compliant cases. So it's not high profile cases, not complex cases, and it contains no compliance concerns. After that, we have second level reviews. They are made by senior analysts. So they will review cases where a concern has been identified by a junior analyst or where the case is high profile or complex. For cases requiring in-depth analysis, the senior analyst will assign the case to an investigative analyst for final determination. I understand that only investigative analysts or higher can make a final decision for cases involving non-compliance. Basically, investigative analysts will review the employer's justification for its non-compliance, and if the investigative analyst finds the employer compliant or compliant with justification, the investigative analyst will issue a compliance letter with a warning letter if applicable. If the investigative analyst finds that the employer is non-compliant, he will assign the case to a senior decision maker. The senior decision maker appears to be the only person who has the delegated authority to render an employer non-compliant. This is very rare that we will have the opportunity to talk directly to a senior decision maker. So our written observations are very important to convince the authority to find our client compliant or to reduce the monetary penalty and avoid a ban if he is found non-compliant. For today's presentation, I will refer to the officers from all levels to one term, which is inspector. So we will not it will not be mixed up between the titles. What period of time is subject to the inspection? So the start date is up to 6 years from the temporary's first day, temporary foreign workers' first day of employment, and the end date might change. So if the work permit is still valid when a final decision is made, the end date of the inspection will be the date of the final decision letter when it's sent to the employer, or the date the foreign worker became permanent resident, whichever date is the earliest. If the work permit has expired when a final decision is made, the end date of the inspection will be the expiry date of the work permit, or the date the foreign worker became permanent resident, whichever date is earlier too. This is very important to check the start date and the end date of an inspection, since it might affect the conclusion of an inspection. If an employer is inspected for events which happened way after the expiry date of a temporary foreign worker's work permit, the sequence of events should be explained to the inspector in a letter, and so we want to avoid non-compliance. The employer obligations during the inspection process, there are quite a few, but what you need to know is that the purpose of such obligation is for the inspector to verify compliance with the conditions set out in the applicable regime. So basically, you need to report at any specific time and place to answer questions and provide documents, attend any on-site inspection, give all reasonable assistance to the inspector, and a failure to collaborate with the inspector might result in, will result actually in additional violations. So you need to be aware of that. Inspectors have extended powers provided by the regulation, but some limits exist. For example, the Supreme Court made a clear distinction between an administrative inspection, also called audit, and this is the process we are in when we are in during a employer immigration compliance inspection, and a difference between this kind of inspection and a criminal investigation. So an inspector cannot conduct both at the same time, since it might lead to an exclusion of evidence. So we made an outline to display all the possible steps of a immigration compliance inspection. And I'm very sorry, this is very, very small and it looks like very big, but it's not. So, and once again, it's from our point of view, because I don't know if it's the real outline that Immigration Canada or Service Canada would explain, but this is what I can tell you from my experience. So next slide. Yeah. So we'll begin by the initial letter. So it This is the first step. The letter will identify the temporary foreign workers concerned by the inspection and ask the employer to provide with documentation for each temporary foreign worker, such as offer of employment, timesheets, pay statements, income tax documents, and business license, policy on psychological and sexual harassment prevention. And after having received all those documents, the inspector will proceed with a summary analysis, which is a paper audit, actually. I usually recommend the employer to send a very well organized response to the inspector. So if found compliant, the employer might receive their compliance letter after a few weeks. And this is better to get a compliance letter 4 weeks after the beginning of an inspection than 3 months, because it can impact LMAA application. Next slide. We have possible incidents during the inspection. So, for example, you can have a letter requesting additional information. Usually, this letter is sent when the officer forgot to ask for particular document relevant to the inspection, or finds that some additional documents might be relevant after a summary analysis. After that, we have expansion of the scope of the inspection. This means that the inspector will add other temporary foreign workers to the inspection. This is very rare, but it might happen in some complex or high-profile cases where the inspector suspects that the violations affect more temporary foreign workers. I will always check if the officer add temporary foreign worker to the inspection without asking for additional documentation for those temporary foreign workers. As I said previously, a violation that affect more than one temporary foreign worker constitute a separate violation for each worker negatively affected. So the adding of more workers could affect a final decision. And the employer should have had the chance to make submissions as requires the procedural fairness rules. This is a basic principle in administrative law. And I wanted to mention that because I'm quite fond of administrative law. This is why I practice in immigration and labor law. So this is very important to check. So next slide. We can also have interviews. Interviews will take place, for example, if a temporary foreign worker claims abuse from the employer, for example, a alleged psychological harassment by manager. So probably that the inspector will conduct interview with the worker, the manager, and a few employees to determine if the employer made a violation. Okay. So I see that there's not much time left and we need to answer a few questions from the attendees. So I will cut my part just a little bit. We can have also on-site inspections, especially when claims of unsuitable housing. So we can go to next slide. Yeah. Another possible incident might be a justification request if the inspector think that the employer might be non-compliant, and the employer will respond with an employer justification letter. So I will go to the other slide. Okay, so possible justification are all provided by the regulations, and I've chosen some that come back more frequently. So we have change to the provisions of a collective agreement, dramatic change in economic conditions, error made in good faith, and accounting or administrative errors. We'll go to next slide. I will choose one that I think is the strike. Well, the strike is quite, it might be common actually. I had once an employer which were concerned by a inspection, and because basically, there was a strike and the temporary foreign workers did not receive their wages. So I think that we would argue in this case for a strike that this is not actually a violation, it's just basic principle of labor law. So the employer respects its employees' right of association and strike right, and an employer is not obliged to pay an employee who do not perform work. And there is no difference between temporary foreign workers and Canadian or permanent resident employees. We can go to the next slide. Dramatic changes in economic conditions. So we have this question, it comes back like nowadays with the economic situation. We have many questions regarding mass layoff. So for mass layoff, usually seniority prevails, but other criteria can be used to select employees for a workforce reductions, such as skill-based selection and multiple criteria ranking. Regardless of the chosen criteria, employers should not favor a Canadian resident permanent or a temporary foreign worker. And the employers should always document the layoffs in preparation for an inspection. We can go to, okay. Error made in good faith. Maybe I can say a case study on that. So basically the transportation costs, maybe the employer have misunderstood that the transportation costs cannot be recovered from the temporary foreign workers in the low wage stream. And the easiest solution actually is to reimburse the transportation cost to the temporary foreign worker and keep a proof of the reimbursement. Okay, we talked about payroll errors at the beginning of the second part, so I will skip that slide. We can also have a notice of preliminary finding. If the inspector determines as a result of the inspection that the employer has committed a violation, the inspector will send the employer a notice of preliminary finding, which describes the violation or the violations and the potential penalties associated with it. This is a second opportunity for the employer to submit detailed justifications. Sometimes when the employer reads the potential penalties and a potential ban from the program, they call us to help them with the rest of the inspection. We usually do not have much time to respond to the notice of preliminary finding, and some corrective action should be put in place most of the time to ensure a good justification for each violation. And next slide. The final determination, so we can have 3 possible findings: compliant with justification and warning letter, and non-compliant. And if next slide. And if an employer is found non-compliant, the final determination letter outlines the applicable sanctions. So the best practice is to verify if the person who made the final decision was authorized by the regulations to do so, and carefully review the final decision with the point-based system provided by the regulations. It's just to make sure that the final determination is correct. So we can go to the questions. I think that we have quite a few. It will be Stephanie.
Yes, thanks, Elisabeth. We do have quite a few questions, so we'll try to cover as much possible. But please feel free to reach out to either one of us. If we don't cover your question, send us an email and we can answer. I'll do my best to answer as many as possible over here. Okay, so let's see. This one came up more than once. So can a foreign worker be dismissed if he is unable to perform his duties? I can answer that one. So the answer in short is yes. So employers often have the misconception that because they're hiring a foreign worker, and that they're bound by the employment period of the LMIA or of the job offer, but this is not true. Yes, they have to respect the obligations under the immigration regulations, but by no means is an employer tied to a foreign worker for the entire duration of the employment contract if there is a performance issue or if there's a justified reason to let go of this person. They do have to keep in mind that foreign workers have the same rights as Canadian workers, and so the general employment laws will apply. So same process like notice, severance, all these things still need to be applied in the process of a dismissal or layoff when it comes to a foreign worker. Unless anybody wants to add, any of my fellow speakers.
I just want to add that's a great point, Steph. So in general, like it's not relevant that they are holding a work permit, but it's important to be mindful of which category they obtain a work permit from. If they receive the work permit and a labor market benefit plan or a transition plan is required, those obligations on the employer still continues despite the employment ends. And the second point is, if you end their employment, it's also recommended to inform Service Canada or Immigration Canada, depending on the type of work permit they hold. So this way you have evidence that their employment has officially ended in case there's inspection. Go ahead, Steph.
Great. Another one is, we covered this, but maybe we can clarify further. Is the employer expected to pay for housing, transportation, and a moving allowance?
I can answer that question. So like with regards to housing and transportation, that only applies to labor market impact assessment under the low wage and agricultural stream. If it's not going to be under those two specific streams, it goes back to contract law, how you negotiate the terms with your employees.
Thanks, Daniel. Another one here is, should the emergency medical care be provided to the temporary foreign worker employee or to their eligible dependents as well? So I can answer that. The regulation just requires an emergency private healthcare coverage for the temporary foreign worker themselves. It does not extend to any accompanying dependents, so you don't have to worry about that. Okay. Let's see here. There's a construction company question. We are a construction company that has hired many foreign workers through the LMIA process. As we all know, construction is at times seasonal. what happens if there is a shortage of work for the winter?
I can answer this question. If I am part of the LMAA process with the employer, I will recommend to add a specific mention on the possible shortage of work during the winter in the LMAA application, so that Service Canada will know that this might happen. And if a shortage of work happens, actually, you always need to follow specific criteria for workforce reduction. It can be provided by the collective agreement, or it can be a business decision. So you need to make no distinction between temporary foreign workers and Canadian and permanent resident workers.
Thank you. Another one here is the employer required to print and save the pages of the offer of employment submitted on the IRCC employer portal? What about proof of payment of the $230 fee?
I can try and answer that question. It's actually a really good one.
Go ahead.
So what usually happens is like the proof of the $230 that is required for work permit application. So when the immigration lawyer prepare those applications, it will be submitted online. And generally speaking, like our law firm would provide the client with a copy of those information to allow them to keep it as a record in case there's an inspection. But if you use Fasken, we also have those information available just in case there's inspection, so we can pull out the document for you.
Exactly. And so you can always log into the employer portal and retrieve the information, but just in case there's a glitch, you know, we can't always rely on technology, unfortunately. So that's why in terms of best practice, it's better that you actually print and PDF a copy of both the fee receipt and with the information submitted. So that way you can avoid any unexpected technical issues in retrieving that information whenever there is an inspection. All right, this one's for Quebec, more specifically. So for Quebec, do employers need to register each temporary foreign worker to the CNESST? Elisabeth, do you want to answer this one?
Yes. Actually, they don't because it's when employers are under the federal card, they need to answer to the labor code, the federal labor code. So they don't need to register the temporary foreign workers to the CNSST. However, it might be a good practice to do so, just to make sure that the CNSST will not knock at your door and tell you that you have not registered, but it's not an obligation.
Okay, perfect. Yeah, so just to clarify, this is for employers under the federal chart. I didn't mention that when I read the question. So yes, for employers under the federal chart, but for other employers, they are.
Other employers in Quebec who are provincially, like it's the province of Quebec, and they are not under the federal card, they need to register to the CNSST for each temporary foreign workers. And they need to register them as soon as possible when they enter Canada and they are hired.
All right. Okay, let's see what other questions we have here. Okay, this one comes up very often as well. What would be considered a substantial pay increase in situations where for the same position and performance, a Canadian would receive a 10% raise? Are we not allowed to give it to the foreign worker?
I can try to answer that question, and then whoever else might jump in can add more comments. This really depends on the type of work permit we're talking about. So generally speaking, for the labor market impact assessment work permit under the temporary foreign worker program, there is a cap, and before last year, the cap was 2%. Now is capped at the inflation rate of that year. So that varies from year to year. Whereas for the international mobility program, there's no such cap, but the pay increase should be reasonable, because if the increase is too substantial, the officer may suspect that there's a change in occupation and not just a normal annual pay increase.
If I can add, so it's not, there's not a specific number. Like, for example, the 10% raise, if you give that to Canadian workers, remember what Elisabeth mentioned, there's always the justification process, right? So it's not to say that you can't give the foreign worker a 10% raise for a promotion if you would do so for a Canadian a Canadian employee, sorry. But you just need to be mindful of, just stop and think whether it would be considered substantial or not. But again, there's ways to frame it. The important thing is to document the employee file, because in case there is an inspection, you want to be able to explain the 10% raise. You want to make sure that it's not, most importantly, it's not a change in the occupational code. So it's not a change in the NOC code. For example, if you have an engineer, you want to make sure that you're not offering, before changing the work permit or the LMIA, that you're not offering, for example, a VP of engineering position, because that would be considered a change of occupation requiring a new work permit. But the 10% raise may not cause a problem here if it's explained, if it's justified properly. So it's not to scare away employers from giving promotions to their foreign workers when it's deserved. So just keep in mind just how to assess it before just freely doing so as you would for Canadian employees.
Stuff to explain really well. So like within our firm, a lot of time client come to us and give us a scenario, then we'll be able to provide like an opinion. So sometime the best thing to do is to consult with the immigration lawyer, so we can let you know if there is a red flag or not.
Yeah, and I will jump on what you said. Daniel just said, we have so many interesting questions still unanswered, but you can still reach out and ask us your question by email, and we will try to reply to you as soon as possible. So thank you for joining us today, and to my fellow speakers as well, Delphine. I think that you learned quite a bit during the preparation of this webinar.
Yes,
so
I did, indeed.
I'm very pleased. And a reminder to please fill in the survey if you haven't already done so. Our next event will be held at the end of May, and the topic will touch on the new Competition Act provisions and how it applies to labor, employment, and human rights. Keep an eye on your inbox for this event invitation. Our upcoming event list is always growing. Please visit the Fasken Institute section of fasken.com to register for events of interest. Have a good afternoon, everyone. Thank you.